Hi there, this is Jonathan Ginsberg. I'm a Social Security disability attorney, and today I'd like to talk to you about tactics you can use to stop harassing phone calls when you're applying for Social Security disability and you're waiting 2 or 3 years, yet your bill collectors don't seem to care and they just want to drive you crazy. What can you do? And I've previously done a video about some of the options. You can certainly file bankruptcy on the debt. You could just ignore the phone calls and so forth. But sometimes it can be very difficult, and certain bill collectors can get really aggressive. They're not supposed to do this, but they may call friends or relatives and try to use that to intimidate you. They may threaten you with incarceration, all kind of crazy stuff. So I want to just kind of clarify what the bill collectors are supposed to be able to do and what you can do. So first of all, let me draw a distinction between bill collectors and actual creditors. So let's say you owe money to Macy's, let's say, or JCPenney. If Macy's or JCPenney call you, they have a little more leeway than a bill collector. Bill collectors are subject to something called the Fair Debt Collection Practices Act that actual creditors are not subject to. Now, both types of creditors are going to be subject to certain rules about not harassing or making misleading statements, but the FDCPA is where the real teeth is when it comes to debt collection defense. And so when you're dealing with the bill collector, which usually you're going to be if you're behind 3 or 4 months or more, this is what you need to know. First of all, the FDCPA makes it illegal for a bill collector to make threats to you that they're not prepared to back up. If they, for example, are out of state and they're threatening to sue you, they don't have the right to sue you because they're out of state. They can get in trouble for that. You can sue them for damages for that. They cannot threaten you with incarceration. There's no debtor's prison in the United States, so they cannot threaten you with incarceration. They cannot call third parties and discuss your debts with them. That's illegal, and you can sue them for that. So anytime something doesn't smell right, a bill collector is taking action that seems overly aggressive. Another thing is they can't call you 60 times during the day, drive you crazy like that. So what I would tell you to do is if you're getting harassed by a bill collector, one thing to do is to record the phone conversations, whether it's through your smartphone or get a tape recorder and just record the phone calls. I've seen cases and been involved in cases where we've been able to win damages from folks because they used improper language or threats, and we have it on tape. Again, this is assuming your jurisdiction allows you to tape phone calls. Where I live here in Georgia, as long as one party, meaning the party receiving the phone call, consents, agrees to it, then we can tape phone calls. Other states, you can't do it, so you need to really check on that. But bottom line is if you can catch somebody doing something improper, you have leverage to actually sue them for money damages or maybe even to offset the amount of the debt that you owe. So that's just something to keep in mind. Second thing is when you're dealing with bill collectors or creditors themselves, it's a business problem. They try to make it personal. They try to make it seem like you are a bad person, that you've got a moral failing. Not having money to pay a bill is not a moral failing. Most of the time when people incur debt, they plan to pay it, they want to pay it. So if you can't pay it, this is a business problem. So you never want to go and try to take money out of your 401k or retirement money to pay a bill collector. It just doesn't make any sense to do that. So you have to just realize it's a business problem. If they try to make it personal, a moral failing, you need to stop that right away and say, look, this is a business issue. Let's figure out if there's a way we can deal with that. Third thing is, if you are not working, you have no assets, you're basically judgment proof. You can tell them to jump in a lake. There's nothing they can do. They can sue you. What are they going to get? If you're not working, they can't come after your wages. If you get Social Security, they cannot go after that. So basically, you're judgment proof. And so what I do for my clients is I will write something called a drop-dead letter to the creditor or the bill collector saying, look, my client is not working. He or she has applied for Social Security disability based on a permanent medical condition. I don't go into detail what it is. And we're asserting our rights under the FDCPA to have you discontinue all phone calls. And if you tell them to stop calling you and they continue to do so, again, money damages. But a lot of times the drop-dead letters will stop phone calls for 6 or 8 months, then they may start up again, send another letter. But I've had a lot of success using a drop-dead letter, and all it simply says is that, dear so-and-so, I'm contacting you about a debt that you allege I owe. Again, you never want to acknowledge or admit anything. At this point, I'm unemployed. I do not expect to see any employment in the near or long-term future. I have no assets. I'm judgment-proof. pursuant to the FDCPA, I'm asserting my rights to have you discontinue all phone communication with me. You may only communicate with me heretofore in writing. And again, written statements they can write you, but even what FDCPA says, if you tell them to stop writing you, they got to stop writing you. Now, normally when you send an FDCPA letter like that, a drop-dead letter, they may sue you. But again, what's the difference? If your only source of income is going to be Social Security disability, it's simply it's just a number. It doesn't mean anything. And down the road, 5, 6, 10 years down the road, the judgment will either expire, or if they renew it, you can probably settle it for pennies on the dollar. So again, not having the money to pay a debt because you're disabled is not a moral failing. It does not mean you need to raid your 401k or retirement money. It simply means that you need to take a little bit of action to stop the phone calls. Real simple thing to do, just write this letter like I described it, and the phone calls should stop. And if they don't stop, make record of it. Try to get a recording if it's appropriate, save all the letters, and maybe you have an FDCPA claim and you collect money from them. How sweet would that be? And I've done it many, many times. So that's kind of an overview of what you should do if you're getting phone calls for debts, whether they're medical or credit cards or anything at all, and you don't want to file bankruptcy at this point, and you just simply assert your FDCPA rights, tell them to leave you alone, tell them you're judgment proof. That should stop the phone calls. And again, if it doesn't, you may actually put money in your pocket for a violation of that federal law. So I hope this has been helpful. If you liked it, please give it a thumbs up on YouTube and a like on Facebook. Subscribe to our channels. And of course, let me know if you have any questions about this or anything else relating to Social Security disability. I'm Jonathan Ginsberg, and I wish you well. Thanks a lot.